Hello everyone, welcome to this KD info session where we will discuss about the legal will in Ontario. So we have Nikhil here joining us today. He is not a member of KD group, but he is a very passionate individual and I have known Nikhil for past couple of years, and he is passionate about helping new immigrants. And I was just talking about how we can get someone who, like, a professional person to discuss about legal will. But unfortunately or fortunately, Nikhil is not a professional lawyer, but he has done his own legal will recently, and he has graciously accepted to present in this session. So just a disclaimer, the information shared in this session is based on personal research only and should not be considered a legal advice. And under no circumstances whatsoever shall the speakers, moderators, or KD group in this session are responsible if any conflict arises due to the use of the information shared in this session. Please consult your lawyer before making any legal decisions. So with this, I would like to hand it over to you, Nikhil, to take us through the legal bill in Ontario.
No, absolutely. No, thanks. And thanks for the generous introduction, Shilpi. Although by background, I'm not a Bengali, but, I've always been interested in the Bengali culture. And when Shilpi and I connected, we have discussed a lot about Bengali things. And, recently we attended Durga Puja together, which is one of my favorite memories while growing up. And at that time, Shilpi mentioned to me about the existence of this group, and that how this group is really actively involved and supports, educating new immigrants about the, various facets of things that could impact their lives. And she asked me if, I could, speak on this topic. And very interestingly, completely out of the blue, just a month ago, I had prepared my own will. Just occurred to me that I should prepare a will, because there are things which you don't have any control over in life, and you want to keep your loved ones protected. So that was one of the reasons I thought about this. So one of the things I would like to add, that all the information that I will be sharing is totally based on my own individual research. Shilpi rightly mentioned, I'm not a lawyer by any means or measures. And whatever I will be speaking about is only applicable in the province of Ontario. So different provinces have different rules and regulations, and mostly we will be covering only Ontario here. And I'm assuming all the participants here are based in Ontario, so they will be covered under the Ontario law. So now,
Sorry to interrupt you. Just one quick thing I forgot to mention, that this call is being recorded, and if no one provides their consent to being recorded, please
right.
drop from the call, and you may listen to the recording later. Okay, sorry for the interruption.
No. Thanks for saying that, Shilpi. So yeah. We all are familiar with the idea of will, that it's just one of the instruments, one of the major instruments which allows a person to kind of dictate or kind of direct how their wealth or liabilities should be, handled once they depart from this world. So with that background, the first thing that I want like to, before I actually start getting into the nitty-gritties of what how to make a will and what all that entails, one of the things that everybody should know is that when somebody is preparing a will, they have complete control over it. So what that means is that they are not bound in what they can write or they cannot write about their assets and liabilities. It is totally in their control. They are the author of that will. And sorry, is someone trying to say something here? Okay.
No.
Okay, perfect.
I would just like to request, if no one is speaking, please go on mute. And if you have any questions, then you may unmute yourself.
Right. So that said, so what basically that means is that if you want to write a will, you are good to go. You do not need anyone's direction. Now, there are certain events, major events in life that can change the whole idea about the will that is in existence. Now, one of the major events is people get married. So if you have a will and you made that will, let us say, for example, when you were single, and then later on you get married, so the will that you had created will become invalid. But there is one situation in which it will not become invalid is if you mention in advance in that will about your plan to get married. So what that means is that you are already aware that your marriage is on the cards, you know when it's going to happen, and you make a mention of a note of that in the will. So if you do that, then that will remains absolutely valid. Now, another scenario is where you prepare a will, you have a will, and you're already married, but unfortunately, you get divorced. Now, if you get divorced, all the sections of the will remain intact except the ones where you are mentioning about your ex-spouse. So, to explain that further, in the future, that will is treated in a way as if your spouse has died. So, that leaves that part of the will completely out of the picture where it talks about the spouse, and the remaining portions remain. Now, when we are talking about the creation of a will, there are many things that you may want to keep in mind, like how do you want to draft a will, what do you want to write in a will. And one of the major components of what you want to do is, of course, a will comes into existence only once a person is dead. And when a person is dead, the will requires someone to execute the will. And so I will be touching upon this topic later on in the presentation as well, about executors and how to choose the executors. But very briefly, one should keep in mind that when you are choosing an executor, do know that they will be undertaking multiple tasks. And what that means is they will be involved in settling all your liabilities. They will need to be involved in all the transactions that will happen after the death of the individual. They will need to make sure that the assets are divided according to the will, and a lot of paperwork, a lot of legalities. So it's quite a task. So it's not as simple as just taking the will, reading it, and just leaving it that way. No. And the expectation is that you are executing the will not as a favor but as a service. So you are liable for the proper execution of it. And many a times, there is a kind of a compensation kept for that executor. And this executor can be a person who may not be related to you. And actually, that can be a good idea if the person or the entity is detached from this whole affair of settling the assets and the liabilities. Now, when we talk about the assets or the liabilities, there are different means and ways to distribute the wealth. One of which is called the named gift way, and the other one is the pooled and split. And as probably you might have figured out through the name, that as an example, what I could right now immediately think of is, let's say there is a house and a car which is your possession, and you want to think, okay, what I'll will the car to the child or the son or daughter, and will keep the house, let's say, to the spouse. So that's one way to distribute the wealth, which is like what I mentioned in the named gift strategy of executing the will. The other part is, let us say there is a house that needs to be sold, and then you have certain assets. So what do you basically do? And the person in this particular case does not have a spouse, or there are only two children involved. So what basically that means is you dispose of everything, and let's say everything sells for like $1 million, and you deduct the liabilities, and whatever remains, you just distribute it to two parts. So those are the two kind of strategies which are popular and which are kind of suggested for the distribution of wealth.
So, one quick question, Nikhil.
Sure.
Like, since you recently made your, will like a month or two
Yeah,
ago,
right.
so what are the challenges that you faced while making that? Because when we talk about assets and liabilities, we talk about current scenario, but say, how do we predict, like, after say 10 years or 5 years down the line, what will change?
Absolutely. Yeah, absolutely. Good question. And more importantly, how do you prepare a will? So let us say somebody after this call goes to sleep and says, okay, you know what, I do not have a lot of time to, study this particular topic. What do I do? But I still want to create a will. So one of the ways to create a will is called the holographic will. What that means is it's a handwritten will. Now, this is the easiest method in Ontario to write a will. All it requires is a pen and a paper and you. So you can sit down on a table with a piece of paper and a pen in your hand, and you can draft a will. No, nothing else needs to be like thought about.
Like no
But
format or nothing, no set format, no rules.
no set format, nothing. But one very important thing, that it needs to be signed. It needs to be signed and dated at the bottom. That is very critical. Actually, when I was researching on this topic, I came across a very interesting story about holographic wills. So back in 1948, there was this very famous incident that happened. So there was this farmer in Saskatchewan, and this guy was in his field, and he actually, for some or the other reason, he came, just under his tractor, and he was pinned down by the tractor. And that day the weather was really bad, it was raining, and this guy was under the tractor for like 10 or 14 hours, and he felt that he might die. So what he did is he used his pocket knife to write a will on the fender of the tractor, and he simply mentioned that in this mess, if I die, everything goes to my wife. And then unfortunately, although he was taken to the hospital, he passed away. And the judges decided that that was a valid will because it was written by him. So holographic will is absolutely the simplest method. The only issue that it poses is that you should not be contradicting in the will. You should not be making statements that contradict each other. But if you keep it simple, straightforward, with all the factors that you need to keep in mind, like, making a note of your assets properly, making a note of your liabilities properly. Now, keep in mind, those don't need to be at the present moment. So if you write a will today and you accumulate wealth over the next 10 years, the will does not have a life. It only comes into existence after the individual's death. So it will continue to remain in existence, and the assets or the liabilities will be divided based on the will after the death of the individual.
Okay.
Okay, so I think we can move to slide number.
Just wanted to pause and see if anyone has any questions, because we saw like a couple of new folks who just joined. So does anyone have any question? Okay. No, let's move forward. Okay.
Okay, now, to make a will legal in Ontario, what are the basic? I mean, it's pretty similar to, let's say, becoming eligible to vote, or like having a driver's license. It must be created by you. So what that means is nobody else you cannot create a will for your parents. You cannot create a will for your brother or sister or siblings. You have to be the author of that will. You must be 18 years old. You must be in a sound mind. And what that means basically is you should be able to know that what are the consequences of preparing that will. Who are the individuals who will be impacted by the creation of this will? Who are the individuals who will be left out of that will? That is also critical. So you need to understand that clearly. And if you can demonstrate that, then you're good to go. Now, holographic will, what other key requirement is that it should not include or involve any kind of mechanical equipment. And what that means is no typewriters, no typing, no computers, no laptop. Because once you do that, then it does not remain a holographic will. And if that is the case, then the other, I guess, the aspect or the other requirement comes into picture, which is having two witnesses. Now, when you have two witnesses, they would need to sign on the will in your presence, and they would need, or of course, you could go to a lawyer, and then there's something called an agreement of execution, where they make the witness sign in front of them and create a record of it, so that in the future, if the witness is not reachable or something happens, then it is considered a proper witness. Now, you also have to keep in mind something very important here, that when an individual is thinking about creating a will, and obviously the will come into existence when the individual passes away from this world, one has to also remember that all the different permutation and combinations need to be thought of. That it is not only the individual who can die, the executor can die, the heirs can die, the people named as beneficiaries, they can die. So this has to be a properly thought about process, that what happens if, let's say, the next of the kin, or the wife passes away, or the child passes away. I mean, unfortunate things can happen. So the will should clearly lay out the trajectory, or the next, I would say, the steps that would be undertaken if such a situation arises. So yeah.
When you said we need to be, this document needs to be signed in presence of two valid witnesses, you mean the holographic one, not the mechanical one?
No, 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 no. On the contrary, when you are creating a holographic will, you do not need any witness. All you need to do is you need to sign yourself.
Okay.
But when you are preparing a will, let us say by typing on a laptop, right?
Mm-hmm.
And you print out and you sign, that's when it requires the signature of two more witnesses.
Okay, got it. And is it like do we need to nominate or as a beneficiary someone who's present in Canada, or someone in India can also
No,
be?
no, no, no.
Doesn't matter.
No, no, absolutely not. I mean, the individual, the author of the will is in Ontario, the son is studying in the US or is based in India or any other part of the world, doesn't matter. Doesn't matter.
And it can be,
Similarly,
the person can be cannot be related by blood, right? It can be I want to nominate to my will to my friend, right?
right, you could do that. A good example is, nominating, I mean, just making a charity a beneficiary. That could come into picture as well. Some people want to do that, very much possible. Now, but keep in mind that if you are trying to create a will which kind of oversees or overlooks the law of the land in an aspect, let's say spouse, that can be challenged.
Can you elaborate on that?
So, for example, if there is a spouse who's totally dependent on you, right, and you say in your will that if I die tomorrow, my spouse is getting nothing. So that can be challenged because per the law in Ontario, the spouse if they are financially dependent, they need to be taken care of. So then they will go under the Family Act, and then of course they can challenge the will, and the courts will have to then decide.
Okay. Okay, good.
So sorry, just a question. So this is about spouse who are dependent fully, like not like independent, right?
That is correct. These are dependent spouses. It can also be applicable in the case of other dependent family members, but then that has to be demonstrated before the court.
And I have one more question. Like let's say I have mentioned about my assets and properly distributed that to my whoever will be.
Right.
But if I don't mention about my liabilities in that legal will, then
Right.
how that will be distributed?
So once the person dies, basically all the liabilities and the assets are clubbed together to form your estate, and the liabilities are taken care of first before the division of the wealth. So
Okay,
let
so
us
if
say,
I don't mention it, then also it will be
absolutely, you cannot, because liabilities is something which is like implied by the law. Somebody has a claim. It's simply similar to a lien, right? Like if you have a house and the mortgage is basically a lien. So if you are planning to sell a house, the bank has the first right to recover the mortgage from you.
okay.
So when you say it goes to estate, is there like a living person or living entity that manages everything?
Right. So the executor could be the one who would be managing the estate. So this estate is the creation of the estate. There's a agency which is called I believe OPGT, Office of the Public Guardian and Trustees. So that is the entity that manages the estates and covers the laws regarding estates in Ontario. So then there's a whole set of laws regarding that as well. So that estate will be created, and then your assets and liabilities would form. So though they combinedly would form that estate, and the liabilities are the first to be taken care of. Even the executor needs to be compensated, and that compensation could be as high as 5% sometimes. So that needs to be taken into account, and once all that is settled in, then whatever remains is then distributed accordingly.
Hey, Nikhil, Shukriya here. So, just one quick question regarding holographic will. Okay.
Correct.
So,
Correct.
suppose, for example, if I write something and then I attest it by my signature and date, how will I certify that? Because I may just write it and keep it at home, right? So, what is the next
Absolutely.
process?
And that is more than perfect. So you don't need to certify anything, as long as it bears your signature, as long as it is dated, and as long as it is written by you using a pen and a paper and nothing else. It's all good.
Okay, so it doesn't have to be binded by any legal documentation
No,
form. right?
No. As I was
Okay.
giving you the example, that gentleman, that farmer who died on that unfortunate night, he simply used his pocket knife to carve out his will on a tractor fender,
Mm-hmm.
and it was
Okay.
considered valid, absolutely
Okay.
valid.
Okay.
But do we need to get it notarized or that
Exactly.
also?
No, that's what I'm saying. A holographic will is the simplest form. You could do it right at this moment. The important thing is that when the holographic will is contested, the challenge is to prove, one, that it is original. Secondly, there is no newer version of it,
Okay.
right? So you would have to find a way and a mean to let the executor, let the spouse, or let the beneficiaries know that this is what it exists and this is the final version of it. And then when you prepared that, you were in a sound state of mind. You were not under any influence. So when you will prepare a will, you basically will write that I and my name is whatever the name is. I'm in complete state of mind, like in the Hindi film mein, so Sakshi jankar pure hosho hawas mein kehta hu, like that kind of a language, to make sure that you know what you're talking about, and then you write and you explain in ample detail what you intend to explain. So if you have let's say, for example, a step brother, so you need to mention that these guys are the ones that will not get anything. Basically, that tells the reader that you are well aware that they could have had a claim, but you don't want to give anything to them.
Okay. Okay.
Hey Nikhil, Sumit here. Sorry, I have a question. So you told us like in the will I can mention like anyone, let's say my family, extended family, they are living in India, right?
Correct.
But laws in India is different and laws in Canada is
Very,
different,
very,
right?
very good question. And that's thanks for asking. I was actually coming to that point in one of my next
Okay,
slides.
sure. Yeah,
Yeah,
sure.
no, but I can elaborate on that. I mean, good opportunity to explain that. So it is not necessary that you need to have one will or one executor. And rightly said that if you are creating a will in Ontario, the laws of Ontario govern that will. But what about, let us say you have assets in India? They are not governed by the laws of Ontario. So there is a probability, or there is an option where you create two sets of will. So you have a house, let's say in Kolkata, and you have a house in Toronto, and you want to say, okay, you know what, the house in Toronto should go to my child, and the house in Kolkata should go to my parents. So yeah, so you'll create a different will for India, and then we will need to discuss about how the Indian laws then operate.
Yeah, no, that is fine. But my question was specific. Like, let's say I have some properties here in Canada.
Correct.
And I know I provided like someone like in my will who is staying in India, but
Right.
that person doesn't have any legal status in Canada, like doesn't have
Doesn't
any
matter.
PR or visited
Doesn't matter.
information, right?
Doesn't matter. Doesn't matter.
Okay.
Doesn't
Okay.
matter.
But
that
then
person,
how their property will, like I don't know, like because he or she cannot come to Canada, right?
Correct. So then the executor of the will make sure that that's how, and if there's no executor, then the court will appoint one.
Okay.
So let us say a hypothetical example that I can think of is, let's say someone has a house in Toronto, right? And then unfortunately that individual passes away, and the parents live in India, right? So what will happen is that the house will get disposed of, all the liabilities will be paid, and if the remaining amount is, let's say, 500 grand, then that will be sent back to the parents in India.
Okay.
That is exactly what the person wants to do, because
Okay.
ultimately at the end of the day it is your property. Like, you are free to decide what you want to do with it. You have every right about it, right, over it.
Okay.
just wanted
Thank you.
to interrupt. Like, we only have 8 minutes and this call will automatically end. So
Oh, okay.
we have two questions. So if you can quickly touch base,
Sure.
and I think that
Sure.
will cover most of our questions.
Absolutely. So what happens if someone doesn't write a will? Now that becomes a case of interstate. That means no estate, nothing. And then there is a law in Ontario, which is like Succession Law Reforms Act, that comes into the picture. Now, I'll just try to elaborate a little more. So for example, I'll give an example, and this is somewhat related to real estate as well. So let us say a husband and a wife, a couple, they have certain properties, and what that means is the property is considered a joint tenancy. And the definition of joint tenancy, basically what that means is that both of the parties involved in that transaction, the husband and the wife, have everything equal in terms of the assets, right over the assets, the liabilities, everything is equal. It starts at the same point, it ends at the same point. It does not end in case of a freehold property, but everything is same. So in that situation, if one of the parties passes away, then everything is bequeathed to the other party, correct? So when we are talking about an interstate situation, in that case, what happens is the same set of principles that is applied. So if let's say the husband dies, everything goes to the wife. But in situations where there's a family, so husband, wife, and 2 kids, if the husband dies, the wife will get first 200 grand of the assets, and then the remaining will be divided equally between the spouse and the children. And then there are certain set of rules which further elaborates what happens if scenario, like if the wife passes away too, then what happens? Then it gets equally divided between the children. If there are no children, then it goes to the parents, so on and so forth. So they do elaborate, but keep in mind, all this is only applicable for married couples. Common law is not treated the same way.
Okay, that is interesting. Okay.
So Nikhil, like just one quick question here.
Yeah.
Like this applies to the people who are legally staying in Ontario,
Absolutely.
irrespective of their status, right? Whether they are on work permit or they are on PR or citizen, like all of them.
No, I don't think so. And that's a
Okay.
very good question, but I'm not 100% sure. But 99% based on my understanding, I think these rules are applicable to permanent residents and citizens. Because
Okay.
I think if you're on a work permit, you are not a citizen or a permanent resident of this country.
Okay.
So work permit is just a situation where you're allowed to work for a particular period of time, right? I mean, you are governed under the laws of Ontario for your daily needs, but this, for example, how should, like the citizenship, I think would come into the picture here. I think so. But for this one, I would honestly admit that I am not 100% sure on this one. But that's a very good question. No, but based on my research, what I was trying to read and trying to understand, I think it's more about permanent residents and the citizens, because then that would also include work permit holders are no different than visitors, and they are no different than study permit holders. They all come under temporary residents.
Okay.
So
So I do have a follow-up question then, like it's more of a general process that I want to know. Like I had a will in the US where, for example, I was also on visa in US, but there the law does allow me to create a will. Like suppose if both me and my wife actually die, then there is a process to send back my kids back to India rather than like surrendering them to the government there.
Right.
So can you just tell me what is the process here, even for a peer holder? Like suppose, for example, if both parents ceases to exist and they don't have any other relations here, then how can we ensure that they gets actually sent over to our parents back home?
So that's a completely different topic, because what will happen is that basically gets covered under the guardian's subject area, and the will, to my understanding, you can only enforce or direct the government for the first 90 days, and then there are certain rules and procedures for how the kids are to be handled and how they come into the guardianships and how the courts take precedence over that, and courts have a say in that.
Okay.
Yeah. So it is not simply a case of you dictating what's going to happen. The courts do have a say in that. Of course, keeping the best interest of the kids. There's a whole section about that, actually.
Okay, so long story short, we can't create a will for that scenario.
No.
In US we can, but that's why.
So I'm sorry if I'm not understanding your questions correctly, but the way I'm understanding is, so let us say you have a house, right? Now, if both the husband and the wife pass away, then, and if you in the will mention that if such a scenario happens, then the house or the proceeds of the sale of the house go to the kids upon them achieving the legal age. So that's the way it will be carried out, that there will be an executor or a guardian who will then make sure that the kids are properly raised. His or her expenses will need to be paid for, the kids' expenses will need to be paid for till the time they achieve the age of 18, and then whatever would remain would be passed on to them.
Okay, yeah. So I was actually not talking about that scenario. What I was talking of was I want to find a meaningful way by which my kids can be handed over to my relations or parents back in India.
Right. Okay. So you want them to go back to India in case of any eventuality.
Yes,
correct?
right.
Okay, right. But so I think that is a completely separate topic, because
Okay.
will is basically dealing with assets and liabilities, and
Okay.
children are a separate subject area. So what we are talking about in the will is how your assets and liabilities will be taken care of, not how your children will be handled in case of both the parents expire.
Okay, fine. Okay.
We only have like 1 minute and few seconds, like 50
Okay,
seconds.
okay.
So, and call will automatically interrupt. But I
Okay.
really wanted to thank you, Nikhil, for coming over and sharing whatever experience you have for making a legal will in Ontario. And
Thank you.
if I receive any follow-up questions, I will make sure to pass it to you. And if anyone from this call wants to reach out to Nikhil, please let me know through KD Group, and I will share Nikhil's information. So we have 1 minute. I don't know if you can quickly touch base about the cost, and
Yes.
then
Can we create another Zoom meeting and then continue this session? Because that
Yeah,
is important.
Sure. I'm okay. I'm available.
you mean right now?
Right now, yeah, because it's in 1 minute, right? So we can create another
Okay,
session.
so if
Join
okay, I
because
are
I,
if,
I last,
Shilpi, you can create it and then we'll share the links in Facebook and WhatsApp and we will all join back.
okay. So let
that
me create one more meeting, and then we can. Are you okay to
Absolutely.
stay on
Yeah,
for a few
absolutely.
minutes?
I can continue talking, and then you can create the group in the background, and
Okay,
we can just
let me
continue.
do that, and it will
So
automatically end, and I'll
yeah,
share.
no worries. We all will be joining again. And I was just trying to explain, the last slide talks about the costs of creating a will. Now, as I was explaining to you, the holographic will, that basically is of course, totally free. You can do it yourself. The other cost, like if you decide to adopt a different process, let's say going to a lawyer, that can be a little expensive in terms of, like, the costs could vary anywhere from as low as $300-400 to all the way as high as it could be, because of the situations. So there could be a situation where all your assets are not simply houses or cars, but you could be the owner of a company. You could have shares, you could have other forms of assets, and then it gets a little more complicated. So of course, lawyers assistance and lawyers level of effort would significantly go up, and that will drive up the cost as well. But always a good idea to consult a lawyer to make sure you're not doing something which later on the beneficiaries would find it hard to work around.